need to do. If I have 10, 15 minutes, I'm fine.
Okay.
Hey, Mike and Justin.
Hey, there he is, my man.
Y'all doing all right?
Okay. Yeah. You saw my note. You can shorten that thing up as much as you want.
Gotcha. Now I'm gonna read it word by word, all the way. I didn't get anything from Justin, so unless you said
I'm pretty humble, so you don't have to say a whole lot.
And for those of you that are logging on, we're gonna get started here in about 3 minutes or so, giving everyone an opportunity to get on. So
excellent.
Kevin, did you say you didn't get my bio?
I did not, no.
Okay, let me see if I can try to resend.
Unless I just didn't pay attention to it. Hold on.
Hello all, John Kennedy calling from TSTC.
All right. For all of you, I'm going to mute everyone so we don't get a lot of background noise. And then I'm gonna unmute our speaker today. So if you're just logging on, I'm gonna mute you. For those of you that have cameras, if you wanna turn your cameras on, we'd love to see you. Don't have to, I understand everybody's working from home. I shave for this, so I wanted people to see my shave. But I'm gonna mute everybody and we'll go here in a second.
Okay.
All right. Right now we're up to 31 participants. 31 participants, just so you guys know.
Good, good.
I'm sorry, Justin, I did get it. I apologize. Okay.
Oh, okay, cool.
I'm gonna wait till about 12:02. For those of you that have logged on, my name is Kevin Riles. I serve on the Fort Bend Chamber Board as your division chair for business and professionals. And we are, I wanna say this is our very first large Zoom meeting to provide you information as to COVID-19 and how it affects your businesses. And we have two dynamic, awesome, oh my God, speakers today. No pressure. Mike Dobert and Justin Markel. And so I'm glad you guys are tuning in. Again, I'm just giving everyone a couple minutes to log on here. See some names I recognize.
That's great.
I love to see faces, but no faces, needed, but love to see faces. We have our illustrious and awesome leader, Carrie, with the beautiful background with the trees and everything. I see you, Carrie. Ryan, I see Juliet, all the chamber staff is on here. All right. This is a great turnout. 38 thus far. It's a great turnout. And there's Miss Stacy Bynes, comes in. The whole chamber staff is on here. I'm loving it. All right. All All right, we're going to go ahead and get started. I want to thank all of you for logging on. I'm just so excited to be able to host this on behalf of the Chamber. My name, again, is Kevin Riles. I am the broker, owner of Kevin Riles Commercial, which is a commercial real estate firm here in Fort Bend area. But I also, more importantly, as of today, am your business and professional division chair. And I just want to let you guys know how proud I am to be a part of the Chamber and how proud I am of the Chamber staff, Carrie et al. They have been working in the background every day in attempting to adjust not only how the Chamber does business, but also to provide resources for Chamber members and Chamber friends. And so as a result of that, this webinar / seminar was put out there as an opportunity to just educate folks on what's going on. These are unprecedented times. I don't know about you guys, but I know my business has been affected as well, as far as closings and banks cutting LTVs and things of that nature. And so we thought it would be a good idea to put these information sessions together so that you guys could learn what was going on in terms of HR. We have the cybersecurity coming up on April 2nd. We're going to do the same format, and I'm sure there are others planned that you'll hear information about from soon. And so with that being said, before we get started, I'm going to unmute Carrie and allow her just to say hello. And then I will introduce our speakers and we'll get started. So Carrie, there you go. You're unmuted. Hold on just a second. I thought I unmuted you. Ah, there you go.
Can you hear me now?
Yes, yes.
Thank you, Kevin, for what you're doing. We really appreciate the time that you're spending to help educate our community, our members. Our plan for the future is to have one of these every Tuesday and Thursday at noon. So be watching for that. We are putting together a financial presentation on next Tuesday. We'll be hearing from bankers. Hopefully we'll have some solid information about the legislation that's going through Congress. Hopefully it's going to go to the House tomorrow and get signed and approved by the president over the weekend, and we'll have information about what that looks like. I think there is a tremendous amount of relief on its way. So thank you all very much. Thank you, Justin, and thank you, Mike, for doing this. Appreciate it.
Thank you, Carrie. All right, so a couple of ground rules on this. I have muted everyone except for our two speakers. I'm going to share my screen here in a second to allow for them to go through PowerPoint. But as far as questions are concerned, if you guys, for those of you that are new to Zoom, there's a chat box at the very bottom of your screen. If you guys have questions as we go along, please feel free to ask those questions to either me privately, or you can ask them as a group. It allows you to ask me privately, or you can just type in and it'll let everyone know what your question is. And I will facilitate those questions to Mike and Justin as we go forth. And then at the very end, if we have any questions from a verbal standpoint, then we'll allow for that as well. All right, so let me introduce our speakers. First up is Justin Markel, who is an equity shareholder, an attorney, and I guess I would say, based on Justin's bio, he advises and counsels employers regarding various employment law issues, among other things. He assists employers to craft employment policies and contracts, and also counsels employers regarding issues relating to hiring, pay, discipline, and termination of employees. So thought it would be great to get Justin on here from an attorney standpoint. It's always good to have an attorney. Shout out to attorneys there, just to let you know what you're doing well and not doing so well. And then we have Mr. HR extraordinaire, Mr. Michael Dobert, who is the owner and principal of HR and Alignment. He provides strategic human resource consulting solutions. Got to know Mike through the Fort Bend Leadership Program, dynamic speaker, always good information. And so with that being said, I'm going to turn it over to whoever is first. And I will start sharing my screen here so that I can bring up the PowerPoint presentation. guys, I'll leave it to you.
All right. Thanks so much, Kevin. I guess I'm first.
Okay, got you.
And I guess just a really quick disclaimer, because I'm an attorney, and of course I have to give a disclaimer. So basically, this is an informational kind of presentation. If you have specific questions about certain issues, then you know, it's always best to go to a professional, like an HR professional or an attorney, to get specific advice about your kind of unique, specific situation.
And just make sure, Justin, and everyone, I'm just making sure you guys can see the PowerPoint. Can everyone see?
Yes.
Okay.
I can
Yes.
see them,
Okay, cool. All right, go ahead. I'm sorry, Justin.
yep. Okay. I guess we can jump down to the agenda slide. So today we're going to be talking about the Families First Coronavirus Response Act. This is a new law that imposes some leave requirements on most employers. We'll also talk about other employee issues, and we'll get into that a little bit more. And then at that point, I'm going to be turning it over to Mike to talk about layoffs versus furloughs, what goes into that decision-making process, pros, cons, that kind of thing. And then also WARN notice requirements. For employers that are covered by WARN, what kind of notice is required and what goes into that. So we can go to the next slide. So Congress really quickly passed this Families First Coronavirus Response Act. And we're looking for regulations to give us a little bit more guidance, but we have the information that we have right now. And what we know is that it goes into effect April 1st. And it's really a temporary measure. It stops being effective at the end of the year. And it mainly provides two kinds of leave for employees. One is a paid sick leave, and one is an expanded family and medical leave. And we'll take each of those in turn because they have a little bit different characteristics. You can go to the next slide. On both fronts, on both the paid sick leave and the expanded family and medical leave side, we have the same definition of a covered employer for the most part. And so a covered employer under these statutes includes private employers with less than 500 employees. And that's really what the statute said. The statute also provided the Department of Labor with the authority to grant a small business exemption. And we should be seeing that in forthcoming regulations. We just don't have those regulations right now, so we can't really say the ins and outs of that exemption, what it's going to look like, what it's going to apply to. But what we do know right now is that when it comes out, it will apply to employers with less than 50 employees. We know that the exemption will be limited to those kinds of smaller employers where providing leave would jeopardize the viability of the business going forward. And just recently, maybe a couple of days ago, the Department of Labor came out with a Q&A about this new law. It also came out with a fact sheet, like it does with other laws. And basically, the questions and the fact sheet make it sound like maybe this exemption, whenever it comes out, is only going to be applicable to childcare related leave. That's not certain right now. So we might see it have a little bit broader application. We might just see it being only applicable to childcare related leave, but that's kind of yet to be seen. Okay, so going with the paid sick leave first. If you're a covered employer, then you have to provide paid sick leave to, or basically all employees would be eligible potentially for that paid sick leave. It's a 2-week leave entitlement. And so for full-time employees, that means that they're entitled up to 80 hours of this paid sick leave. Now next bullet should say part-time, sorry. But for part-time employees, It's really the number of hours that they would normally work on average on a 2-week period. There's only 6 qualifying reasons for leave under this paid sick leave component. And they kind of break down in like the first half and the second half. On the first half, we're really talking about the employee caring for him or herself. So the employee, if the employee is subject to a quarantine or an isolation order related to COVID-19, that could be a qualifying reason. Presumably under this first reason, this includes shelter-in-place orders probably. You could also take paid sick leave if a healthcare provider has advised you to stay at home because of COVID-19 concerns. This seems to be broad enough to include, possible exposure in addition to just having symptoms. Under the third qualifying reason, if the employee does have symptoms and is seeking a medical diagnosis, that could also be a qualifying reason for leave. And then the last, number 4 and number 5 really have to do with caring for other people. So an employee could take paid sick leave to care for someone who is subject to a quarantine or isolation order, or possibly someone who has been advised by a healthcare provider to self-quarantine because of COVID-19 concerns. These are basically the same as number 1 and number 2, but the employee is caring for somebody else in those conditions. And then the 5th reason, an employee is caring for a child whose school or place of care is closed or whose child care provider is unavailable due to COVID-19 concerns. As we'll see later, this 5th reason is shared between the paid sick leave component and the family and medical leave component. And so we'll see how that interacts between the two, if that's the real reason for taking both kinds of leave. Number 6 is kind of a catch-all. They just threw this in the statute, and we don't really know what kind of other conditions could qualify for number 6. So we're kind of just holding our breath on that one. Okay, so for paid sick leave, like how is it paid? Is it paid at full pay, or is it paid at some other amount? If you're taking it for reasons 1, 2, and 3, then it's your regular rate of pay up to $511 a day, or $5,110 total. For 4, 5, and 6, it's 2/3 pay, and you have kind of a commensurate cap, $200 a day or $2,000 total. 1, 2, and 3, remember, that's really caring for yourself. If you're staying at home under a quarantine order, or you're caring for yourself because you have symptoms and you're seeking a medical diagnosis, or your healthcare provider has told you go home. 4, 5, and 6, really caring for other people subject to quarantine orders and whose healthcare providers have recommended that they go home, and also caring for children who are out of school.
And Justin, just want to remind everybody, if you have questions, feel free to type them into the chat, and we can view them, as we go, and I can intersperse where there are breaks. So if you have questions on some of these slides, or please feel free to enter those questions in the chat, either to me directly or just in general, because Justin and Mike will be able to see the questions. So sorry about that. Just want to remind them.
Oh, no worries. Okay, so how does this paid sick leave relate to other kinds of leave the employer might provide just kind of voluntarily, like PTO? Well, the employee can elect to use this paid sick leave under the statute before other leaves. And the employer can't really say, no, you got to use your PTO first. Something also to note is that any leave that's taken before April 1st can't really be credited towards this paid sick leave entitlement. Okay, so that's the paid sick leave component of it. There's also a family and medical leave component. This is an amendment to the Family and Medical Leave Act, and it kind of it changes a lot of things, but only for like one specific reason for leave. So it applies to so the covered employer definition we talked about earlier also applies to this expanded family and medical leave component. Unlike the paid sick leave part, where it just applies to any employee of a covered employer, on this side of things, on the expanded family medical leave side of things, we're really only talking about employees who have worked for 30 days for a covered employer. If you're an employer that already has to deal with FMLA compliance issues, this is also a different definition than maybe what you're used to. Under traditional FMLA, we're talking about employers with 50 or more employees and who employ 50 or more employees within a 75-mile radius of a work site. So it's really a different definition. It's more broad. The leave entitlement under this expanded family medical leave is 12 weeks. That's the same as under traditional FMLA, but we'll see that it's a little bit different in the way that it's paid. Okay, under this expanded family medical leave component of the new law, there's only one qualifying reason for leave, and that's that the employee can't work or telework because they're caring for a child whose school is closed or whose childcare provider is unavailable because of COVID-19. Note that this is the same reason as like number 5 when we're talking about reasons under the paid sick leave component. And so we'll see later in some hypothetical examples that someone who can't work because they got to take care of their kids at home could potentially take leave under both statutes.
So we have a question. Yes, I think it's ANSA or Ann. Hopefully I'm not saying that incorrectly, but we can get copies of the PowerPoint. In fact, we're recording this and it will be available on the Chamber's website. Another question was, do you know if there's anything for employers with more than 500 employees?
Not that I know of. Employers with more than 500 employees are not covered by this this law. And when you get into like how do you count employees, it's a little bit more nuanced than just counting people. There's aggregation principles like a single employer principle where you basically have two companies that employ employees, but they're so interrelated and intertwined and they're so interdependent on each other that a court will say, no, that's just one employer, even though it might be like two corporations. You also have another principle, which is what's called the joint employer principle, where you might count jointly employed employees when you figure out how many employees you have. The common example is like a staffing agency. A staffing agency might like employ the employees initially and then send them to a client work site where maybe the client has authority to hire and fire and direct their work day to day. And in those circumstances, I think most of the time, those employees will be considered jointly employed. So basically employed by both employers.
Gotcha. Pretty asked, is there any proof needed to allow sick leave?
That's kind of an open question right now.
Okay.
And that's something that we're going to be looking out for when the regulations on these statutes get issued. On the paid sick leave side of it, we don't have any regulations. All we have is a Q&A and a fact sheet so far. On the expanded family and medical leave side, we do have regulations in that, like, so this is an amendment of the Family Medical Leave Act, and we do have regulations under the Family Medical Leave Act, but it's unclear right now what the certification procedures are going to be for requests made under this new amendment.
Gotcha. And then Tony asked if an employee has been out for the past 2 weeks before April 1st with no sick leave available, will they then get the 2 weeks pay? It's a good question.
Not
Employees
under
now
this
before
new
April
law.
1st.
Yeah, not under this new law.
Yeah.
So you could have, if the employer has like a PTO policy or a sick leave policy, then that kind of leave might be payable under those employer policies. But the new law doesn't go into effect until April 1st. And so you wouldn't be obligated to provide any paid leave under this new law until April 1st. And in fact, there is guidance that seems to suggest that if you do provide leave before April 1st, it doesn't count against the leave entitlement.
Gotcha. And then last for this round of questions, and then we'll continue on. Jack asked, just to clarify, this does not apply to companies with less than 50 employees.
Yeah, this gets back to the covered employer exemption. It was on like one of the first slides. So the Department of Labor has the authority to issue a regulation that creates this small business exemption. That's all the statute says. It says the DOL has the authority to issue this regulation that creates the exemption for employers that are under 50 employees and employers under 50 employees for which like providing the leave would jeopardize the business as a going concern. Now, what I can gather from the Q&A and the fact sheet is that that exception might only apply to leave that's relating to childcare. So if you go back to the paid sick leave qualifying reasons, there's like 6 of them. And just gleaning what I can from the Q&A, I'm not exactly sure that the exemption will apply to reason number 1, 2, 3, or 4. So it's possible, and we don't really know because the regulations haven't been issued yet, but I think it's possible that the smaller employers will still have to provide paid sick leave for those other reasons. It's kind of an open question right now because we don't have regulations. But I think it would be a little risky to assume for now that the exemption would apply like wholesale to all employers under 50.
Gotcha. All right, so I'm gonna continue the slides. Guys, keep the questions coming. I'll stop him here in a second, to answer any other questions you may have. Just want to kind of pause there for a second. So am I on the right slide, Justin, or?
I think we're on number 13.
13, okay.
Yeah. Okay. So this expanded family and medical leave is it's paid a little differently than traditional FMLA leave. The first 2 weeks of leave are unpaid. Now the paid sick leave entitlement could be used for this 2 weeks, like you could overlap it. The Q&A that just got released seems to indicate that the employee could also kind of sub in PTO or vacation leave or sick leave if they're available under employer policies. Under this expanded family medical leave, it's also paid these last 10 weeks. They're also paid at 2/3 the regular rate of pay, up to $200 a day. This is consistent with the pay you'd get under the paid sick leave time for reasons 4, 5, and 6, which are basically caring for other people. Okay, so again, I guess just to reiterate, employees who can't work because they have to take care of kids at home, and their kids are out of school, or their schools are closed, or their place of care is closed, or they can't find childcare because of COVID-19 reasons, they would be eligible for both paid sick leave and for expanded family medical leave. And so typically, I think the way this would work is that the employee would take the paid sick leave first, and that 2 weeks would overlap with the unpaid portion of the expanded family medical leave. And then the employee would take 10 weeks or up to 10 weeks of the expanded family medical leave, and all of that leave would be at 2/3 pay, up to those caps we were talking about. Okay. Now, there on the expanded family medical leave side of things, there is a reinstatement right, and it's because it's an amendment of the Family Medical Leave Act, which has a reinstatement right. Basically meaning that the employee, when they exhaust the leave or the reason for taking the leave has gone away, they have a right to be reinstated to the same job or an equivalent position. There is an exception in the statute for employers with fewer than 25 employees, but it seems pretty limited. Basically, the employer has to be able to prove that the employee's position doesn't exist anymore due to economic conditions or other conditions that affect employment that are COVID-19 related. And also that, go to the next slide, the employer has to make reasonable efforts to restore the employee to the equivalent position. And then even if those efforts fail, that you have to make contact during this 1-year contact period if an equivalent position becomes available. So it seems pretty rigorous. But if a smaller employer with fewer than 25 employees can meet all 3 of these elements, then they don't have to reinstate the employee as a statutory right. Okay, so I guess just to put all this together, I put together a couple of hypothetical examples. So I guess we can go through these. One is an employee is under a shelter-in-place order, but the employee can telework. In this case, the employee would not be entitled to paid sick leave or expanded family medical leave because under both, the employee would need to be able to not work or telework because of a qualifying reason. Then can we go back one slide? Okay. All right. So for this example, employee doesn't have kids, so we don't have to worry about that, caring for kids who are out of school reason. And the employee can't work because there's a shelter-in-place order, and the employer's on essential business. In this case, like for employees that have to do their job at work, and then the shelter-in-place order basically makes them stay home, the employee would be entitled to 2 weeks under the paid sick leave part of it. But this reason wouldn't give rise to leave under the expanded family medical side of things. Okay. What if an employee can't work because they're caring for somebody who's been advised by their doctor to self-quarantine because of COVID-19? This is one of the reasons under the paid sick leave. So the employee would be entitled to paid sick leave at 2/3 pay. But this in and of itself is not a qualifying reason under the expanded family medical leave. So their leave entitlement would stop there unless they can show that they'd be entitled under some other statute or rule. And here I mentioned regular FMLA in the slide, really because there could be scenarios. I think for the most part, COVID-19 won't qualify as a serious health condition under the FMLA, but maybe in severe cases it could be. If you have an employee who, for example, has a parent who's in the hospital being treated or trying to recover from COVID-19, that could be a serious health condition. So that could give rise to leaves under other laws, and we'll touch on that a little bit later.
Got a question for you, Justin. Can you clarify, this is from Crystal, can you clarify how paid sick leave gets paid from day 1, but FMLA leave doesn't pay for the first 2 weeks? How do those two contradicting rules work together, or am I misunderstanding?
Yeah, so the paid sick leave entitlement is it's a 2-week leave entitlement, and it would be paid either at full pay or 2/3 pay, depending on what kind of reason you're taking it for. If you have an employee that is taking paid sick leave and then is taking expanded family medical leave, what we're probably dealing with is someone who just has to be at home to care for kids out of school. And in that instance, we're really only looking at 12 weeks total. We're looking at 2 weeks under paid sick leave. We're looking at 10 weeks under family and medical leave. The first 2 unpaid weeks under the family and medical side would basically overlap with the paid sick leave component.
All right, Crystal, if that doesn't ask you questions, just hit me back here. I'm gonna let Justin keep on going with the scenarios. All right.
Okay. So I guess this is the example that we just went through. So it's 2 weeks of paid sick at 2/3 subject to caps, and then 10 weeks of expanded family medical leave at 2/3 subject to caps. So in total, you end up with 12 weeks of leave. And this is really, you can only get this scenario if the reason for leave is caring for children whose schools are closed or whose childcare providers are unavailable due to COVID-19 concerns. Okay, now this has been like a lot of information all at once, and there's a lot more information coming day by day. But as of today, the best resources to go to is the DOL. There's a Q&A, and I've got it linked here. There's a fact sheet that I also have linked. If you are a covered employer, then there is a poster notice requirement. So whenever you can get back into the office, there's a requirement to post a poster, which is linked here. There's also an FAQ about how to post and what counts as posting. You might be able to post it on a company intranet site, or you might be able to email it out to everyone. That might satisfy your requirements for this general notice. I should also note that my firm wrote an article about this I think it was last week, which pretty much goes over what we just talked about.
All right, and just again for everyone's knowledge, we're gonna post the slides and the video of this on the business and professional section of the Fort Bend Chamber website within the next 24 to 48 hours. And the only reason I'm giving that time frame is because we have to render this video. It might take a little while to render the video, so it's an appropriate size. So if you didn't get these particular, unless you're doing a screenshot right now, resources, it will be available within the next 24 to 48 hours. I also wanted to have an opportunity just to them, if they needed to scrub anything, they could as well. So just a reminder for that.
Okay. All right. Really quickly, we're going to go through some other employee issues related to COVID-19. If an employee shows up to work, is it okay to take their temperature? The EEOC says yes for now. And I've linked the pandemic preparedness information that the EEOC has recently updated in light of COVID-19. If you do take their temperature, of course, the information that you get about their temperature is confidential and has to be kept in separate files, separate from their personnel files. I should note also, if you, as an employer, know or become aware that one of your employees has been infected with COVID-19, and you know that employee has had contact with other employees, it's probably a good idea to inform those employees, hey, you maybe want to get tested just to make sure that they're on top of things. Of course, you wouldn't disclose the name of the person who has COVID-19 because of ADA confidentiality requirements, but it is generally a good idea to inform employees if you think they might have come in contact with somebody who does have COVID-19.
Hey, Justin, so most of my agents are independent contractors, but I'm assuming that you're basically saying disclose is always the best tack to take as it pertains to if you have an infected coworker in our particular situation?
Yeah. I should note the EEOC guidance mainly based on statutes or interpreting statutes that they enforce, and that really only applies to employees. Also, the ADA would only apply to employees, not contractors. But just as a general, general best practices, I do think it's a good idea to inform contractors also, hey, we believe that you might have come in contact with somebody who has COVID-19. Of course, you probably wouldn't want to disclose a contractor's name who has it either. I wouldn't say it's because of ADA, because the ADA doesn't apply to contractors, or the employment provisions don't apply to contractors. But at the same time, there's other common law privacy things you'd have to worry about, like you could possibly be liable for some kind of privacy tort, like public disclosure of private facts or something like that.
Gotcha.
If you do disclose that someone has it, or if you disclose that that particular individual has it.
Gotcha. All right, thank you, sir.
Sure. Okay. Really quick, some additional things to think about. We touched on this very briefly before, but there might be circumstances where an employee, him or herself, or maybe a family member of the employee has COVID-19 and it's a very bad case, that might give rise to FMLA leave obligations if you're a covered employer under a traditional FMLA. Of course, that leave would be unpaid. Similarly, if you have an employee who has a very bad case of COVID-19, that could possibly, in some circumstances, be considered a disability under the ADA. And I'm trying to use my words carefully because I think in most instances, having COVID-19 probably doesn't qualify as a disability. But in some particular bad instances, I think maybe it does. And in those cases, providing unpaid leave as a reasonable accommodation might be on the table. Something else to consider also, employers normally provide paid leave of some kind, whether it's PTO or sick leave or vacation. Those policies probably are still in effect unless you take them back, which is probably not a really good HR move for morale and stuff. And then also check your ordinances. So far, the Austin and San Antonio sick leave ordinances have been enjoined, so we don't really have to worry about them yet. But the Dallas one, I think, is still up and going, and it starts enforcement on April 1st. And so if you have offices in Dallas and you got employees who work more than 80 hours within city limits in a year, then that's also something to consider. That sick leave under that Dallas ordinance would be in addition to any sick leave under the federal sick leave component of this new law. It would also be in addition to the expanded family medical side of it. So something else to just keep on your radar. There's a lot of laws that deal with sick employees and family members of employees. And I guess lastly, what I wanted to talk about, I've been getting a lot of questions about, well, okay, I don't want to do layoffs yet, but I want to do reductions in pay. Is that okay? Generally, yes, but something to consider. For hourly employees, generally you can say, okay, starting tomorrow, I'm going to start paying you like X number of dollars an hour instead. And so long as that's over minimum wage, you're generally fine. I'm assuming there's no employment contracts. For exempt employees, something that you need to be mindful of is that in order to satisfy a white collar exemption, that's for executives and certain administrative employees, you have to pay them on a salary basis, which means that their pay has to be fixed and kind of irrespective of the quality or the quantity of their work. So if you say, I'm reducing your hours, or the number of hours you have to work in a week, and I'm reducing your salary by the same amount, then the employee could argue, well, you're not paying me on a salary basis anymore. And for all those hours I worked over 40, and you didn't pay me overtime, now you owe me overtime. So something to keep in mind, that reductions in pay really shouldn't be tied in any way to a reduction in hours for white collar salaried employees. I think with that, I'd like to turn it over to Mike for layoffs versus furloughs and warning considerations.
And Mike, as we go into your portion, guys, we just have 35 more PowerPoint slides to go. I'm joking. Mike is very efficient with his PowerPoints, but we did have a question pertaining to your section. I just want to give it to you in advance. So as you go, Raven asked if about the furlough and mandatory notice language today. The actual language, I guess, to go out. Well, her exact question is, I hope we have time to get through the layoff, furlough, and mandatory notice language today. So she has some questions around the mandatory notice language.
All right, well, we'll start with that. You can hear me?
Yes, I can. Yes.
Okay, wonderful. Good afternoon, everybody. Justin, excellent job. If I understand that question correctly, it's something that I've had a number of calls over the last few weeks with clients. The paid sick leave, the expanded FMLA coming up April 1st, and how does that affect it? And the timeline's narrowing. We're going to talk about this, but any decisions you're making to furlough or lay off, really making sure you have a bona fide business reason you're doing it. It's not just going to be a workaround for the forthcoming additional regulations. And so you have a narrowing window, and you'd certainly want to be mindful of working quickly to do those if they are legitimate and so forth. So we can circle back on that question if you have further questions. If I didn't answer that correctly, we'll talk a little further. So on the subject of layoffs versus furloughs, this has been, as I mentioned, a very frequent question here recently. The short version and how I really differentiate: a furlough, you're still on the team, but you're on the bench. It's a timeout, okay? And so in essence, to that point, you have not lost employment. You either have a reduction in hours or you have no hours, but you're still employed. And there's two pieces to this. Number one, and I faced this in 2008 with the recession and title insurance, for example, where an organization says, I've got tremendous talent. I don't want to disengage or let them go because I'm going to need them back. So that's one good piece as far as a strategy of a furlough versus a layoff, that you have talent you want to retain. We just need to take a time out as a team together to make sure we can sustain the business as we're able to resume. The other thing from a morale issue, if you're an employee in these difficult times and you're not working, that's a hardship. But at least if you know you have a job versus you're going to be looking for a job with millions of others, that's also a consideration. Keep in mind, when you do a furlough, you're continuing employment. It's either reduction in hours or no work, but they're still your employee. Okay, so you're also not making any promises. As you go through the furlough period, and we'll talk about this with the WARN Act, it may get to the point where, you know, I'm not guaranteeing you a position back. We're going to watch this together as a team. We're going to stay together, and we'll evaluate as it goes along. Justin hit on a very big piece that's so important with regards to wage and hour. And here in Texas, primarily, we fall under the Federal Fair Labor Standards Act. A lot of states that some of us may not touch on, such as California and others, have state-level wage and hour laws. But the short version of this, as questions come up, Mike, do I have to pay them during a furlough? What goes into that? First and foremost, I think Justin hit on it wonderfully. If you're not exempt, you get paid for what you work, essentially. But if you're exempt, particularly under the executive, professional, or executive administrative professional, there's outside sales and IT. We'll kind of leave those out of scope for the moment, but we can follow up with questions on those. Once you meet the job duties test that qualifies you to be exempt, then there's a salary basis test. And for the executive administrative professional, you have to be paid at least $684 a week. And there's very few considerations in which you can dock an employee who's paid on a salary basis due to being exempt without jeopardizing that classification. So there's two things. One thing, among others, is if I'm a exempt employee and within a 7-day Fair Labor Standards Act defined work week, which I know we don't all work 7 days, a lot of us do, but that's where you kind of draw the line in the sand to say, for the purpose of calculating overtime, did you go over 40 hours? So within that, for an exempt employee, if an exempt employee performed absolutely no services within that FLSA 7-day work week, then you don't have to pay them that salary. However, if they did any kind of work among de minimis, if one of those days they answered some emails, they did some text messages or what have you, then that constitutes work performed. Even though it seems a little bit compared to the whole week, it'll jeopardize that. The one thing the law does speak to is de minimis. De minimis would be you're relieved for the full week. We're not going to pay you. Do not do any work. But if I call you to say, hey, where's the key to the cabinet? That could be considered de minimis. If you were to do this, I would encourage you to have something in writing that says very specifically to these employees, you are not to perform any work whatsoever without my written permission, and make it very clear. Salary adjustment in a furlough. I experienced this in 2008 again with the title insurance, and it became a big question. We had escrow officers, basically a position that went to 32 hours versus 40. We don't want to lose you. We're all going to have to take some sort of adjustment. At the time, and Justin may be able to offer some more information, you've got to be very careful about that. As Justin mentioned, you can't go up and down based on how many hours per week, but can you make a one-time adjustment across the board? Say we're reducing the expectations on you. I want to be careful, as Justin mentioned, reducing hours, and we're going to go ahead and make a one-time adjustment in the salary basis. And as long as you're maintaining that $684 per week threshold, there's a little risk there, but I've seen that done. So it's something to consider, and talk to counsel further or call me further. We can look at it more closely. The layoff is a little bit different in that we're separating from employment. And it could be that we're laying you off, you're no longer employed. We hope to call you back at some point, but you're not continuing that employment relationship as such with a furlough. So let's move past that slide. And again, as we have questions, we can certainly answer those. All right. So here's the other question that comes up very often is the selection process. Anytime you're doing a layoff, anytime you're doing even furlough, what have you, there's always going to be that question of why me and not somebody else. And obviously, we all want to be fair and equitable. We want to be non-discriminatory in our selection process. And somebody in their heart could feel, well, gosh, why me and not somebody else? So there's three kind of considerations here. Number one, LIFO, last in, first out. I started my career as a federal contractor. They were very clean, very conservative. If there was a reduction in workforce, last in, first out. Okay. The second one, which is kind of middle of the ground, a little bit of liability, not as much as what we're going to talk about, but it's based on skills. So consider this situation. I've got two people. Matter of fact, I've got a client. And so previously, before I became involved, they had a separate controller and HR person. And with some business adjustments, they said, we really have to combine these positions. And I've got one person that can do both jobs based on a skill set. The other one can't do both jobs. So in that situation, you'd want to have good documentation, and it may be the resume, competency analysis, something that says, yes, April does have the combination of skills that can allow her to absorb both these jobs where Peter does not. So documentation is king as you go down this direction or this path. A lot of clients have said, I may have mentioned it earlier, Mike, if I do LIFO, last in, first out, the last person I hired just happens to be one of my best performers. I'm very fortunate to have found that talent. So you certainly can determine who stays and goes in a furlough or layoff based on performance. But that carries the responsibility of good documentation. Performance reviews, corrective actions, things like that. I often talk to clients about the HR perfect world and the real world, and I encourage great documentation, obviously, in the HR side of it. The truth of it is sometimes businesses say, Mike, we had some conversations. I meant to do some more documentation. Just evaluate your risk. if you're going to make a decision, just know where that risk is. And if someone were to claim it was because of an illegal reason that you let somebody, or you kept somebody else and let me go, you've got to be able to defend that. You're guilty until proven innocent in essence of it. So be very careful with that. I know we got a couple questions. As we move on, I'm happy to take them, or we can continue.
We have quite a few questions. Raven asked, will employees be eligible for unemployment during furlough with the new COVID-19 Act?
That is my understanding that, the layoff's a little easier in the sense I've lost employment. But my understanding of unemployment, my experience over the years, is there's also partial benefits. So, for example, if I've had to reduce hours, thus reducing your income, and generally it's state by state, but by more than 20%, yes, they could file for unemployment and perhaps get partial benefits determined by the state. Or if I'm furloughed, yes, I'm still employed, but I'm not scheduled. Because of this, I'm losing money. So that would be something to file with the TWC in Texas or otherwise. And it is my understanding that there could be some consideration with that. Keep in mind that with unemployment, you're always concerned as a business owner about your tax rate. There's a high volume of unemployment claims going on. Think of the situation in which somebody is not able to return after medical leave. They've not become well. You can't continue employment. They file for unemployment. There's a medical chargeback protection that says this is no fault of mine. So that's one of the considerations there in that situation. And I think specific to COVID-19, there's going to be some insulation, whereas the feds are giving some grant money to the states to help support the system and give a little bit better benefits. So in short, if someone files unemployment, hopefully you'll be able to offset or avoid it being a liability back to you.
Gotcha. Next question is, what if a salaried employee did not make the $684 a week prior to the furlough?
Well, here's a couple considerations. The $684 increase took effect several months ago. And so if they are, I'll put it this way, when you think of exempt, the 5 buckets, the executive administrative, the professional outside sales, and computer. Outside sales, you really don't have to maintain a specific salary threshold. It could be more so commission. But in those, particularly those top 3 that were affected of that salary level going from 455 to 684, if you're not meeting that salary basis secondary to the job duties test, then they're really non-exempt. You can either bump them up or you treat them as non-exempt. And you'd want to be careful about mixing exempt, non-exempt within the same position. So you would want to meet that salary threshold. And if not, you'd probably want to talk to Justin or myself. And I certainly am happy to answer any questions. You'll have our contact information. There's never an obligation to call me with a question.
Gotcha. What qualifies as a one-time adjustment in salary? If reduction in hours/salary has been made by a company in the last few years, would an adjustment under current circumstance not be allowed?
I'll also welcome Justin's comments on this. From my experience, when that did come up in the title insurance, again, you don't want to be bouncing back and forth that we've made these adjustments. In this particular situation, I want to speak to the situation we're in. We have to make some business decisions, and we may have to reduce hours. And so maintaining the salary basis is important. But my understanding from my previous experience is we're making a one-time adjustment. We're not watching this week for week. As Justin mentioned, and the hours go up, we'll adjust by that piece of it. So it's something to consider. I believe we're in a window of opportunity we can do that, but do not fluctuate. And if you continue to do it more than one time, I think you're jeopardizing your classification to some extent because you're not maintaining that salary basis and recognizing the limited times you can dock or adjust that salary.
All right. When I lay off employees, should I pay them any pending vacation time, or they can choose to keep? They can choose to keep. I guess you're trying to say it when they come back to business.
So here's my thought on this. For a layoff, it's a separation of employment. Speaking specifically to Texas, whether or not you pay someone out at the time of termination, carryover rules, and all those sort of things. In Texas, that's whatever your plan is, your policy. So if you say in your policy that a lot of times when I write a handbook, it's if you leave on a voluntary basis with a 2 weeks notice, we'll pay you out. If it's involuntary, we won't. So I would encourage you on a layoff that you could, number one, follow your policy, separation from employment. If you have PTO, it's there. Other states like California consider it compensation. You have to pay it out. Now, whether or not you could say to the employee, well, do you want us to hold this back? You could, but if your policy says, as long as it's it's not involuntary, we didn't fire you, and you're doing your part, we're going to pay you out, I would say pay them out to be consistent with your policy. That's come up under furlough as well. And so, yes, you could allow somebody to use their PTO during a furlough, but as far as a payout, there's not a separation of employment. So a little bit more discretion under a furlough or layoff. I would say whatever your policy is your policy. In handbooks, employment's at will, you usually write them to say we can actually amend our policy. So maybe that's a reflection in these type of scenarios to look at that.
All right, and then final question here.
Kevin, sorry, just to interrupt really quickly. This might not apply to anybody on the call, but just in case, under the Dallas ordinance, the sick leave ordinance, if you have a separation of employment and then you come back within 6 months and you weren't paid out, then the employer has to give you that time back, or has to basically reset you from where you were when you separated.
That's outstanding point, Justin. That falls under the Davis-Bacon Act for federal contractors and some other considerations that mandate paid sick leave. That's an excellent point, Justin. Thank you for adding that.
Sure.
And then 2 quick things here.
Please.
One, I want to just do a time check, guys. We're at right at almost 1 o'clock. I think from looking at the size prior to, I think Mike is close to being finished here. But 2, if you do have any other questions, you will have contact information for both Justin and Mike after the call. So just want to be a good steward of you guys' time. I'm gonna ask these questions. Daniel, some guy named Daniel Menendez, I don't know who that is, but he asked, how would an employee currently under FMLA status impact being able to furlough or lay off?
That's interesting. Justin spoke with great consideration to the job protection under the FMLA. And so my experience, and I refer back to example of 2008, there's layoffs and significant layoffs. And so when you look at your layoffs, you have people identified in a layoff, as an example, that are on the FMLA. The question is going to be, would this have occurred regardless of them being on FMLA? And it's not just them being impacted. So that's number one. This would have occurred regardless of them being under the FMLA. The other thing is strategy. If you're going to do waves of layoffs, in that situation, I would not include them in the first wave. Okay. So reserve them so they're not the initial ones impacted. They're not alone. It's not just because you're on FMLA. Yes, there's job protection. I have this conversation with a client that I'm having a conference call again this afternoon. What happens if that happens? Another option is to say, well, while they're on traditional FMLA, they're not getting paid. Under this expanded FMLA, they would be getting paid. You're getting reimbursed by the government. So do you maintain their employment status under FMLA? And then upon their return, say, hey, I want to catch you up as to what occurred while you were gone. A number of people, not just you, have been impacted by this layoff. We were observing your FMLA period, but now that you're back to work, we'd like to let you know how this may have impacted your position. So the latter may be a little bit more conservative. I have seen it's where they're notified during it. Some people would say, I'd rather know now than wait. But for the job protection piece of it, perhaps an option is to wait till they return. And either you're not paying them under traditional FMLA or you're paying them under the expanded and you're getting reimbursed.
All right. So I'm there are a couple more questions, but I'm gonna wait until you've gone through the rest of your slides. So Camilla,
yep.
And just give us a second. I know we're losing a couple folks probably because of the 1 o'clock time frame, but I want Mike to have an opportunity to get through the rest of his slides because it may answer some of the questions that you have.
Absolutely. 2 or 3 slides left. We'll make them brief. Question comes up. If you're laid off, separation from employment, COBRA, state continuation. Okay. But during a furlough, the question has come up. And so during a furlough, when somebody's not working, am I able to continue their benefits? Go to your plan document, your summary plan document between your broker and your third-party administrator, whomever. I've seen language that says if you are not working the average of 30 hours per week, you're not eligible. Therefore, you're still employed, but I have to offer you COBRA. I've seen other plan documents where it's written into the plan document that the owner or those in decision making have the ability to go ahead and continue insurance during a period of eligibility not being met. Chances are within that plan document and the premiums they're paying a little bit more for that discretion. Here's what I'm hearing from brokers and so forth, and is that a lot of companies are going to the carrier, primary carrier, or a stop loss carrier if they have self-insurance, and amending their plan, which could increase their insurance. The last thing I'll share with you on that I heard is that several of the carriers, I'm not speaking on their behalf, but some of the Blue Cross Blue Shield have said, I don't care who's paying me, they're on a furlough. If the company wants to pay the full premium, we'll work with them. Check with your plan document and check with your carrier. And that's really the consideration there that you'll want to help guide you. And I think a lot of people across the board, including brokers, are trying to work with people, same as landlords or anybody else. So let's go on to this next slide here, and I'll come back to any questions on that. All right, last 2 things. One of the things you have to consider when you're doing a layoff and a furlough, if it lasts long enough, is what they call the WARN Act. And this is a very brief representation. There's a lot more detail to it as far as mass layoffs, plants, closings, what have you. But in general, federal level, and Texas defaults to federal level, if you have 100 more employees and you're going to lay them off and it impacts 50 or more employees, you need to give a 60-day written notice. And the spirit of that is, look, if you knew the plant's going to close coming up, please tell me, because I don't want to be a situation where I just made a financial investment in a house or car, or I could be using that time to be retrained or what have you. So keep that in mind. There's more detail to it. The 100 or more employee account, there's some things you wouldn't consider represented on the slide. But for the most part, even employers with over 100 that I'm dealing with aren't really, at this point, having an impact of 50 or more. But it's something to keep in mind, and obviously Justin and I or other resources you have can better guide you. On the last slide I want to mention, and we'll maybe have a moment for questions, but, 2 more slides, I apologize. Employment loss means just that. You've lost employment, it exceeds 6 months, the layoff exceeds 6 months. And also consider a furlough where the reduction in pay, you're still employed, is more than 50% and lasts more than 6 months. With that, I've shared with clients that if you get 4 months into it and you don't see a foreseeable end to that, then build that communication up front into your furlough letter that if we get that far, we'll communicate. And then 4 months into it, try to provide that 60-day notice. And then I think there's one more slide, then I see some questions. Last slide here, and I don't know if it applies. I have several multi-state clients. I'm sure Justin deals with the same. Look for many WARN laws. California, for example, says if you have 75 employees and you're laying off 50 or more. So that's something we can all dig into if you have individuals in these specific states. So with that kind of brings to a close this section. Any opportunity for final questions, and then as Kevin mentioned, you'll have our information and call anytime. I'm happy to answer any questions, no obligation, and I'll let Justin speak to that as well.
Sorry, I started talking before my mute was out. Let me see here. I think we answered, well, layoff. Yeah, I think we asked that. All right, so if you are a temporary salary, if you do a temporary salary adjustment, perhaps 6 to 9 months, and a reduction of hours for all staff, would that be okay?
Yeah, I think it's okay. Again, you've got to be very careful when you start adjusting the salary basis. In my experience in council, and this was several years ago, and I don't think this part's changed under the Fair Labor Standards Act when it was amended, I think, in 2004. But again, it comes down, you can't flip-flop up and down. How many hours this week, I'll adjust by this, what have you. It needs to be a one-time adjustment, in agreement that, we're going to go to 4 days versus 5 days, and we're going to make this adjustment, and it needs to meet the salary threshold. So I think you're in good shape there, but I would encourage you to have further conversation with myself or your counsel.
All right. Camila asks, do I need to provide a written/formal notice of layoff to my employees?
Yes, I think that's very important. Even if you're not large enough for the WARN Act and so forth, typically you'll have some sort of basic letter, either furlough or layoff, that says, for example, due to business necessities, you don't have to go into the details, that we're forced to make a decision in order to sustain the business. We're going to have a furlough or layoff. Your position's impacted. You have the right to file for unemployment. This is what will happen with your benefits, and this is how we're going to communicate with you. And so anybody needs that, they can reach out. I have some template letters, and obviously Justin would be a tremendous resource as well.
All right. 2 more questions, and then we'll do it. So King, I can answer. I can try to answer the question. King has a question. Can the chamber consider doing a webinar unwrapping the stimulus package once it's released? Lots of questions in there, especially as a small business owner that need to be weighed against the items discussed today. Yes, that's something that we can consider as far as the BNP committee. And I see Juliet already shaking her head, and Ryan looking at the camera confused. No, I'm kidding. But yes, that's something we can try to put together, King, and go from there. And then Raven, do you have templates you can share for layoffs? Never mind, he just answered. I'm sorry, I didn't read the second part of the question. So, guys, we will have, again, the slides up with their contact information, but just as a last, can you guys give out your work phone and email address just verbally real quick for those that might be taking notes?
Yeah, Justin, go ahead.
Sure. I was going to give out my office line. Okay, so phone number is 281-207-7697. And then email address is J like Justin, Markel, M-A-R-K-E-L, @ and it's our firm initials, RMWBH.com.
Excellent. And my information, my mobile, it's best to always catch me, 281-889-9075. Email is going to be Dobert, just like Robert with a D, MDOBERT, and it's at HRIN alignment. So make sure to keep the I in there, HRNalignment.com. And in closing, I want to thank everybody for participating. I think Carrie said it yesterday. The most important thing on behalf of the chamber is for us all to be here for our community, regardless of members, non-members. It's just time for us all to help each other. So certainly on behalf of Justin and myself, and we're grateful to be able to help people.
And on behalf of the chamber and the business professional division, I want to thank everybody for logging on as well. Juliet, I'm gonna unmute you. Any final comments or upcoming programming that you want to shout out before we get off?
Yes, thank y'all so much for participating. We look forward to continuing these seminars. King, we will certainly look into experts who can speak on behalf of the stimulus. And please note on your calendar, next Tuesday, we have a finance seminar at noon. And then on Thursday, we have a Hackers Playground seminar at noon as well. So please mark your calendars. Check out our calendar of events because we will be uploading these seminars to the calendar with the login information. So if you have any questions that the chamber team can help you with, do not hesitate to reach us. Thank y'all so much.
All right, guys, that will be it. Until we meet again, I'm going to end the meeting. I'll see you guys on the next call.
Thanks, Kevin.
All right, thank y'all.
Bye-bye.